What is GM? GM is an American automotive company founded in 1908. General Motors manufactured vehicles for brands such as Chevrolet, Buick, GMC, and Cadillac. Ignition switch case. In 2001, a GM engineer approved the manufacture of a new ignition switch. Before the switch could go into production, other engineers had been aware of the fact that this switch did not meet required specifications. Regardless, GM engineers approved the installation in select vehicles. By 2004, GM received numerous reports regarding an ignition switch failure where the engine could be shut off while driving. Regardless, they decided it was not a safety issue. Consequences of this shutoff would be the airbags would not deploy, the loss of power brakes, and power steering. They decided that this problem did not warrant a recall. These are some of the ethical quotes in effect. 72 to A, B, D, J, 77 1II, NIII, 77 2I, NII, 72 B, 72 2C. Alternative actions for this ethical breach. Do nothing, cover up the issue. Correct the faulty ignition switch and recalling all the cars with existing issue. Upon the issue's discovery, leak the information to the press. Unfortunately, GM chose the first course of action, doing nothing. Analysis of actions. 1. Do nothing. Main violation is 72A, negligence, since the company knew about the issue but neglected fixing it. Other violations are 72 2B, 72 2C, and 77 1II. 2. Recalling all the cars. This fixes the issue, however, it is costly. If GM refuses, engineers must report the issue to PEO. 3. Leaking the information to the press. This could fix the issue, however, this could lead to the loss of jobs. Also, this violates 77.3 duty to employer. The decision. A combination of these alternatives could address the issue. The engineers who knew about the issue could have presented the issue to their manager. If they did not act, they could whistleblow to the CEO. If nothing happens, they must go straight to PEO. Tort law. This case deals with tort law, which addresses financial recovery related to a loss where the defendant owed the plaintiff a duty of care. The 3 conditions necessary to demonstrate tort law are: 1. Defendant owed plaintiff duty of care. Defendant breached said duty of care. Defendant caused harm to plaintiff. A relevant legal precedent in this tort law case is the Donahue v. Stevenson's ginger beer case, which occurred in 1932. The designers and the manufacturing company, GM in this case, owed the public, and specifically all consumers of the product, a duty of care with regards to public safety and well-being, even in the case of an absence of a contractual relationship. Another relevant case is the Hadley-Bryan case, in which, in this case, there was reliance on the engineers of GM for their special skill. Analysis. In this case, consumers of the vehicles and those related to them are the plaintiffs. The tortfeasors is General Motors. The 3 conditions necessary to demonstrate tort. The first condition relates to the defendant owing the plaintiff a duty of care. In this case, General Motors could owe consumers of the vehicles and those related to them. Secondly, General Motors breached their duty by their faulty product, and thirdly, they caused injuries to the defendants. Liability. In tort law, it is possible to recover the cost of losses or injury as a result of a failure in duty of care, provided the claim was made within 15 years of the original act and within 2 years of discovery of the failure in the duty of care. There are exceptions to these limitations of liability. If the injured party is a minor or limited capacity, or if there's an intent, General Motors, to hide the tort, which applies in this case. In this case, since tort was proven, there is a liability. General Motors should be liable for the costs and injuries of the consumers of the vehicles and those related to them. The final decision. In the case as presented, a court would likely find in favor of the plaintiff, consumers of the vehicles, and those related to them, as tort has been proven. This will follow the legal precedents set in Donahue v. Stevenson and Hadley-Bryan, as they owed a duty of care to the plaintiffs and reliance on their specialty. As a result, they will be able to recover any damages from General Motors.